point out is that we are recording this. So if anyone misses it or wants to get a copy of it, please let us know. Same thing with the PowerPoint deck. I'm happy to circulate that afterwards. There's a lot of information that we're going to cover today, and it's something that's easily done. So if you need it, no problem. And please let me know if anyone's having trouble hearing me or there's a problem. Please, raise your hand or send us a quick note in the chat. My colleague Brian Moffett, who's presenting with me today, is monitoring the questions and answers section and the chat section. So if you have a particular question, please feel free to raise it. With that, I want to sort of get right into things. A little bit about myself. Again, my name is Anthony Davis. I'm a partner at the firm of Santomassimo Davis, and you can see here in our bios, along with my colleague Brian Moffett. We spend a lot of time working on trademark and intellectual property matters, from helping companies pick the right brands and trademark strategies, registering trademarks, enforcing them, and then all of the things that come out of that in terms of helping executives and leaders of companies like yourselves to make good decisions about selecting brands, policing them, monitoring them, and making sure you're making the right decisions to help your company be successful. Today's agenda is on the screen, and what I will do is give a brief overview of our firm in case anyone hasn't worked with us or doesn't know about us. And then, sort of the big picture of today really is an outcrop of hearing from clients since the pandemic started, and then as people sort of started to return to work and started to get back to business, a lot of companies started doing a lot more focus on online selling, online marketing, obviously the remote work, the remote sales, the things that we're doing right now with the webinar. But we started getting a lot of common questions. So for companies that were traditionally focused on, bricks and mortar sales, a small percentage was internet marketing and selling. They hadn't really focused on it. And we saw a lot of common questions, issues arising in the last few months. And then Brian and I thought, well, let's sort of put that together and bring it into one webinar and help executives like yourselves understand these issues and be able to help with making good decisions internally at your companies, whether it's on your portfolio or not, to manage trademarks and branding issues, but to know what are the best practices or good branding practices, how to select, register, maintain, and police trademarks. Again, there's a lot to that, but we boiled it down to some of the basics to help you understand it and make good decisions internally at your company. Also to understand the basic policing and protecting trademarks from infringement. What are the key things you can do or should do to do that? And then really the second half, the last three items on the agenda, really turns to a focus on some of the key things that we've seen happen to clients, again, as this pivot to a much bigger focus on online and remote selling and marketing and working, is issues like cyber squatting, common issues that come up with online marketing and social media challenges for protecting your brand, selling on online marketplaces, the Amazons, the Etsys, the eBays. What are the rules of the road or the game there, what you should be doing? And then finally, one that we talk about a lot with clients is the Customs and Border Patrol, especially if you're having goods made in foreign jurisdictions and shipped into the country, or even if you're not, just to sort of have the Border Patrol monitoring, watching for products bearing your trademarks. It's a pretty simple step, but a key one for any business. So we wanted to include that. That's kind of the big picture. We have, we're going to keep this on track for an hour. So there might be slides where we don't go in depth on it, but it's really sort of to have it all there in case you want to refer back to it. But it's really to sort of focus on trademarks and branding, sort of in the general IP world, but focus on trademarks and branding practices, and then turn it to more of the key things that we see coming up all the time in terms of the online selling. So you have a basic understanding of those issues. So if they come up in your company, or you hear about something happening, at in the executive team meetings, you can weigh in effectively and with knowledge about how these things work. So again, I'm one of the partners at Santomassimo Davis, and our main offering is outside general counsel. We're really a business-focused law firm, where our main office is in Parsippany, New Jersey. And what we really try and bring to small and mid-cap companies that maybe don't have their own legal staff internally is to bring a full-time team law department at a part-time cost. So we have and typically do work out fixed fee structures to replicate like sort of in-house departments, but we have a great team of business-minded lawyers. And rather than having one or two people on your internal staff, we bring the whole team. And we've been doing that for about 10 years, and we have clients in many different markets, but our focus is in the New York metro area and the Philly area, but we have clients everywhere. And that's sort of in a nutshell. And Brian and I work together on a daily basis, giving guidance to clients with these intellectual property trademark issues that we're going to talk about today. So big picture, intellectual property. These are the basic items or types of intellectual property. It's trademarks, copyrights, patents, and trade secrets. And so a lot of times we're dealing with what's the difference of those things. So our focus here is going to be on trademarks. And here you can see we've boiled it down. They can be words, phrases, symbols, designs. They can also be elements of something like sound, smells, and colors. Those are kind of rare ones, but it can also be trade dress. Trade dress is how the product looks, like the shape of the Coke bottle has its own unique qualities that can be protected from other people infringing on it. And critical to all this is really the trademark is your brand name. It's what everyone identifies you as the source of those goods or services, distinguishes you from competitors, and it's really your reputation in the marketplace. One of the things I always say is when we're talking about trademarks in particular is that it's really about sales and marketing. If anyone asks me, well, is that a strong trademark, or how good is that trademark? What courts would look at is say, well, how much have you sold and where, and how much have you spent on marketing? So sort of, that's a really strong, even if someone has a registered trademark, if they have, that's very strong rights to have, but really it comes down to, sales and marketing for all trademark disputes, all evaluations of the value of a trademark. It's sales and marketing. Sort of to contrast that trademark to the other key forms of IP, again, just want to review, you have copyright, it's on the screen now, and that really protects the original works of authorship. So you have an idea or original work, you fix that in a tangible medium. The day you do that, that becomes, you have the original, and if anyone wants to copy it, they need your permission. And the copyright laws are very strong in this country on that front. Patent, we're all familiar with that. It's got to be innovations, inventions, things that really advance the current state of the art. Again, that is something that you can file for, register. That's a much longer process, more involved process than trademarks. But for a patent, again, one of the key things is you would have the exclusive right to exploit that and sell it in the United States for a certain time period. And it really wouldn't matter what the name is or the brand or the trademark. No one would be able to sell, for example, a chemical or a pharmaceutical that cures some illness, that no one else could use it except or sell it and make it without your permission, regardless of what they call it. So that's probably typically thought of as the strongest form of intellectual property rights. Harder to get, expensive to get, but once you do have it, you have exclusivity on a nationwide basis. Um, the fourth type that we always remind people of is trade secrets. Uh, Again, sort of the opposite of trademarks, copyrights, patents, where you're filing something with the government that's fully available to the public to review and read. A trade secret is something you don't want to let people know about. You can see we have the Coca-Cola image there. Think about how amazing that is, how long that company's been around. It's worldwide, and there's very few people that know that trade secret. So it usually is recipes, formulas, techniques used by a company. It could be your, certain information you have in your company about certain processes. It doesn't have to be about making the product, it could be about how you run your business. But there are statutes that regulate that, and it really comes down to having policies, limiting people's access to it, monitoring that, and really being aggressive in protecting your trade secrets. And the stronger you do that, it doesn't really matter what the secret is, it will be protected if someone who is not supposed to take it or have access to it does that. The courts do protect trade secrets pretty vigorously. So sort of that's the big picture of things. And I've got a few slides here where I'm going to talk about, sort of the specifics of trademark, but the trademark, here's the definition of it. I wanted you to have that at your fingertips. And one of the things, we're all familiar with trademarks, and it's something, in one of the slides I'll talk about how it's really a cognitive exercise, right? A lot of the words we'll hear today is about what do people thinking? Is it confusingly similar? Confusion. These are all things that happen between the ears and the brain. And I usually talk about that when I'm talking about trademarks. So it's how do we identify things, right? We see a symbol like for Starbucks and we think of coffee and the other things they sell. You see you driving down the road, you see the McDonald's yellow arches, and your brain goes right, you know what that is, and it's a symbol of something. And if a company has a good reputation, then it's a symbol of their goodwill. And that's really what you're trying to protect, is you're trying to protect your good reputation that you build up over time, so it's not diminished, tarnished in any way by a competitor or someone using your brand or your image or your trademark in such a way to take your customers' attention away or diminish your standing or your goodwill. And it's something that's been around a long time, as we all know from early days, even in England and the Tsarist Russia. Trademarks and symbols for people's products has been commonly used for a long time. But that kind of gets to the core of it, and what I want to convey to anyone about trademarks is it's really this association, right? The thinking part, and the more sales and more marketing you have, the more it elevates people's awareness of your product, and then the more critical it is to protect it and make sure it's not injured or damaged, that reputation, by someone else's infringing use or unauthorized use, because it really takes away from the thing that you've worked hard to develop over time, which is that brand reputation. So kind of the two things that we talk about with trademark owners is use and protection. And those things weigh into things that affect the value or the reputation or the goodwill of your trademark. So these are the things that you're usually calling a lawyer about. Hey, someone's misusing my trademark. We're seeing it on their advertising. We're seeing it on products we haven't authorized. They're using it in comparative advertising. Any use or misuse, you've got to really police, watch, look for. Things get reported internally from anyone on your team or from friendly vendors or people in third parties that you work with that see something at a trade show or online, in some meeting. You have to be vigilant and make sure that you protect and you take action. So monitoring, and this is what we're talking about today, not only in the traditional sense, like I talked about, monitoring at trade shows and on the shelves at stores and in traditional forms of marketing, but really looking at marketplace for infringement. We've over the years seen such a Oh, such an array of different misuse of trademarks, and the rules of the game keep changing with the way things are searched and found online. But it's really matured, and there's a lot of tried and true things that you have to do and watch for. And one of them is just be online, be like a customer, be actively searching and looking for your products and looking at your competitors, and not only looking at just superficially looking at their websites, but looking at the code on their website to make sure your company's name is not in the metadata or keywords of their websites. These are all things that someone on your team should be doing to monitor. You're selling it through channels. Maybe you've got distributors, master distributors, wholesalers, however you're selling it to ultimately to get on the shelf to retailers or online. You've really got to be watching it, because things are happening, and it may not be readily apparent to what's happening. The other thing we talk about is maintaining good records with clients. So your sales records, your marketing records. If you get involved in a trademark dispute or action, that's one of the things the attorneys will be asking you for. Okay, show me your sales records. Show me your documents about marketing. Again, those are the two key things. If you know that and you can be prepared for that, you can really help with the success of fighting, infringement on your marks.
Tony, on that, one thing we often ask the client to track is the date of first use. When you apply for a trademark, the USPTO is going to ask you for 2 dates: the first time you ever made a sale of the good or offered the service, and the first time you did so in interstate commerce, really across state borders. That's really where the federal government comes in, and that interstate commerce. And if you ever get in a dispute with another entity as to who had the mark first, you're really going to want to have good records of when you first started selling.
Yeah, that's an excellent point about, timing can be everything in some of the disputes, especially if someone starts using it in a remote jurisdiction or area where you're not really fighting in the same market. And then all of a sudden, one of you or this competitor you may not be aware of, your footprint grows, and all of a sudden you're tripping over each other for the same customers with a similar name, again, confusingly similar or close to it. So those are the things that you have to be ready to deal with. So one of the things that helps with that is having good guidelines with branding. So you've got a product, you've got a name. We'll talk a little bit later about how to pick good names, strong names, enforceable names. But here, whatever name you're using, if you have existing trademarks and brands, you really have to have guidelines for your own customers to use it, right? If they're reselling or incorporating your products into their products, make sure you have clear guidelines and guidelines for your employees to use the trademarks internally and externally. You want to make sure it's very consistent across all advertising, across all your promotional materials, social media posts, email campaigns, product packaging. I know this sounds fundamental, but we've had a lot of clients where the marketing team online does it one way, the people doing the packaging are doing it differently, and neither of them maybe match exactly what the trademark registration is. So it's really sort of like having a unified approach to making sure you have these guidelines, and they don't have to be that complicated. It just has to be consistent across the entire company. And really, that part of that basic branding policy is to avoid improper use. Don't let other people use it in a way that you don't like, right? Again, that diminishes your distinctiveness. So if someone changes the colors and puts it in the wrong spot on a package, or they use half of your trademark, not the whole thing, on some product, you have to stop it and enforce it. And that's the kind of thing where you have to have a policy where if they're not doing it right, then you don't sell to them, or you get compliance immediately. Because one of the downsides of not enforcing, being consistent, enforcing, monitoring other people's uses is sort of the worst result could be is potential abandonment of your rights, right? So if you let it be widely used, every customer can just freely use it, put it on their own products and put it on their websites, and all of a sudden you're not controlling your trademark rights, then it might be hard to go enforce it when you go enforce it against someone and they say, well, yeah, but you don't enforce it against anyone. You let everyone use it, therefore we're free to use it. And courts, have taken the position in many cases where you can abandon your rights by failing to enforce or police.
And one of those, Tony, and one point there is if you're going to license your trademark, you don't want to avoid a naked license where you're just letting these other entity use it without, insisting on certain quality control guidelines and standards that, you want to have spelled out in the license agreement. So someone doesn't accuse you of having a naked license and, someone then comes along, as Tony says, and tries to cancel your mark down the line.
Yeah, thank you, Brian. Excellent point. So these branding basics, we're going to now talk about some of the sort of the do's and don'ts, but here's some of the basic do's. Again, a lot of this is, might be for, each topic might be a deeper, longer webinar, but we just wanted to summarize it here so it's front of mind for everyone when you're, doing this, maybe this pivot from traditional selling to more of an online marketing presence, where it's even more important to be consistent with branding. So here, color, typeface, size, appearance, background. We can't tell you how many times we have trademark clients come with some issue, and every example they give us of their trademark looks different from online to packaging. So consistency is really key. And then how you're using the trademark in messaging. Again, these are some basics, but it's worth reviewing. Trademarks are adjectives, right? Don't let it become a noun. Don't let your team use it as a noun. And we give some examples here, right? Apple smartphones are popular. That's the right thing, the right way to use it as an adjective, but incorrect. Wegmans is popular. Don't want Wegmans to become a noun. And so here's some other examples where, in the possessive form, it gets misused a lot. And we see that a lot when you've got to watch it, help your team get it right, review all your marketing materials and your websites and all your messaging, and make sure that you're following some of these basic do's and don'ts. The other thing that we see is not only how it's used in sort of the adjective versus the noun, but also use it, make it stand out. Make it the biggest thing on the label. Make it emphasized in everything you present and use. Here's just some examples, and we've used some companies we've done work for, like Samsung, Agfa, Eat Clean Bro, which is a local well-known company in New Jersey, if anyone's seen their billboards on the highways. But it's a very simple messaging, but initial caps, bold, very simple things, but you really have to be consistent on that. And then here we again give an example of like a do not. It's again, they're not nouns. They should not be used in the plural form unless the trademark is in itself in the plural form. Again, these are just, we highlight these because we see it all the time and we're constantly helping clients clean that up, but that's stuff you have to really be aware of. And the next slide here is really another big do and don't. The thing we see a lot too is the improper use of the trademark symbols. We spend a lot of time with clients sort of reminding and highlighting what are the right symbols to use on their products and in their packaging and their marketing. So here we've sort of listed all the main ones. You cannot use the circle R for a registered trademark unless you have a certificate of registration, which I will show on the next slide. You have to have the gold sealed certificate to use the circle R. Very strict application of that rule. If you use it without the certificate of registration, you could lose all of your rights to actually obtain the registration. But before you get that, and while you're thinking about it and applying, the TM to your products, or before you've even applied for registration, you're thinking about names, you can use the TM for products. A lot of people use SM for services, but they're interchangeable. But the use of the TM, there are no rules on it. There's no rules about where to put it, how to use it, but we always recommend using it. If you're going to be claiming that the name of your product or your brand, your service is a trademark, as soon as you start creating content, online, paper, whatever, use the TM in connection with it. You're signaling to other people, third parties, like, hey, I'm making a claim to this. This is a trademark. It's not just a word or a description. It's our brand. The Circle C, again, that's for copyright. You have to have a copyright registration, either pending or filed. But actually, let me back up a little bit. For the use of the Circle C, again, you don't have to have a formal registration, unlike trademark. You can use the Circle C, the word copyright, on any original thing that you've authored, a paper, a book, a song, a painting, traditionally, the software code these days. But you can use the Circle C, the date or the year that you created the original authorship or work, and your name on that without filing anything or doing anything. That's kind of unique to copyright. The P, the Circle P, you have to use that, as we said here, is the notify individuals that it's the copyright for audio works. It's something you kind of rarely see, but it means something unique. And then again, to have a patent, you cannot say that you have a patent pending or a patent registered unless you do. Those are things you have to obey. But for the trademark world, that Circle R is really critical to only be used once you have the certificate of registration. And on this next slide, here is an example of one we obtained for a client. There's issued by the U.S. Patent and Trademark Office. It's got a registration number. It's got that gold seal on the bottom left. That's what you have to have in your hands to use the Circle R. But again, you're free to use the TM or SM at any time. And I've got the next slide here.
Tony, if I could, there's a question from the audience about what would a typical trademark branding guideline include, and that was sort of the last slide, the do's and don'ts in terms of changing it. So I just quickly even Googled it, and I got Microsoft's. As an example, they basically say, the logo should only be on a horizontal surface. Don't alter the typeface. Don't use on a busy background. Have proper contrast. Don't use it and too closely juxtaposed to other entities, logos, words, graphics, etc. So even if you were the folks at home, so to speak, if they were to Google branding guidelines, they come right up, and they're publicly available. They have a lot of do's and don'ts, so that would give you Microsoft is probably an excellent example of guidelines.
Yeah, and they make those publicly available so everyone knows what the what the rules are. But yeah, thanks, Brian. That's really good. Yeah, and the branding policy, it's really it's like a user manual on the do's and don'ts of referring to and using the trademark. We've seen lots of them over the years. They're usually, it almost will seem like it's something prepared by a graphic artist. That's what it'll appear like, because they'll be talking about font size and color and usage and location and all those kinds of things.
Even right down to the number of pixels, that you should have in the definition and the contrast.
Yeah. The next slide here is really sort of to reinforce this, what we just talked about, of the Circle R versus the TM. So here's some of our clients. We have Stacker 2, well-known nutraceutical brand, and they can use the Circle R. They've been using it for 20 plus years in connection with the specific products and services that they sell, for which it was registered. So I'll just go back for a second too. You'll note on the trademark registration certificate, it tells us this is an international class 33. If you see that in the middle of the page, this is a client based in the former Soviet Union, what is Latvia, and they sell cognac and vodka and other distilled spirits. So you could use Shustov in connection with selling cars, and you wouldn't infringe this trademark owner's rights. And that's a real key distinction here, is in the trademark world, is you don't own the name for everything. You own it for the goods and services you're selling and that you list on your trademark application, and maybe sometimes related goods. There's kind of a little circle around that for related goods. Like if you're selling makeup, a related good may be perfume, and clothing might even get related to that. And here we've got a client who's just starting out, but they have the leafy basket. and it's the TM. So they're not registered, but they're freely using the TM on all their apps and websites and all the things that they're doing. Um, maybe Brian, you want to comment about this next one. It's really kind of a key point that we talk about with clients in selecting trademarks.
Right. This is, when we get a new trademark to search, we do first a knockout search to make sure there's not something that's obviously, the same. Then we dig a little deeper to make sure there's not things that might be a synonym or a word in a foreign language that has the same meaning once it's translated. But basically, you want to find a mark that's, stands out in the marketplace, both from a branding point of view and a legal point of view. In order to be federally registerable, it takes about 3 months before the examining attorney will examine your application. And at that point, they'll do searches of their federal, USPTO trademark database to see, if there's anything the same or confusingly similar. So that's one hurdle. And you also have to be aware of common law rights. Folks who are using the trademarks out in commerce without registering them, they can also be a pitfall, and they develop rights without registering it, even though the registration affords a lot of additional benefits. You see the various levels. This is, something you learn in the first week of taking a course in law school about trademarks, the varying levels of strength of the marks. As we'll see on the following slides, the most powerful or the strongest mark is the fanciful mark, which is something that's made up. Next is arbitrary. It's an existing word, but it's something like Apple. It's being used in a way that really has nothing to do with the product. What does Apple have to do with the computer? Suggestive is the lowest level of trademark that will be protectable. Once you get below suggestive, descriptive and generic marks are not protectable. You can't register those. So I think in the next slides coming up, we have examples of each of these different categories.
Yeah, we do, and that's the analysis. I think if to convey to the people that are listening today, executives of companies, like this is where you can really bring a lot of value to your team if you're thinking of new names or new products. This is kind of the step you want to be educated in, so you don't have to keep calling legal counsel to keep doing these searches. But you do that basic screening. Is anyone using it? Is the website available? Is it, check the USPTO database, and then sort of do this evaluation of where it falls on the scale from fanciful, meaning no one, if you look at the trademark, you hear it, it gives you no idea what product is being sold, all the way down to generic, which is, like, you know exactly what it is, like aspirin, that used to be a trademark, but we all know it as a product. So it's lost its ability to be an enforceable trademark. So that's kind of the spectrum. And as this next slide really emphasizes, and again, it's one of the things we talk about all the time, if you really want to be helpful to your company and your team, it's this cognitive part. Use your own common sense and experience, especially if you know your industry, your market, like it's between the ears, right? So if you hear something or you see a symbol or you hear a name, where does your brain go, right? It's just now we know because of all the sales and marketing over the years, we've been educated and are aware. If someone says Apple, we think of really awesome computers and watches and phones and all this smart technology, but it's that brain step. And I think that's a really key thing I wanted to convey today is to anyone listening. It's not like you just look it up in a book and here's the answer. It's all that understanding and experience from the current state of the market and the products and who's selling what and how things are referred to. And
I was just going to add that, in terms of when an application, for instance, is examined by the USPTO, they won't just look to see whether the mark looks the same or sounds the same. It's this term of art. What's the commercial impression? Do the two marks give the same commercial impression to a reasonable consumer? So, that's that impression or the thought process you see on this slide.
Yeah, and that's the main. Yeah, exactly. That's a great point. That's really the main thing that we think about. If a client calls us and we don't know anything about their industry, we do our homework and we try and see what we can see and understand it. But if there's a name or a combination of words and a phrase that means something in the industry, it'll be important to know that, to evaluate it. So when someone's pitching something in your company for a new product, you can have a reaction to it, like, well, this is what I think of when I hear that. And that's where If it's fanciful, you won't have any idea. If it's generic, you'll know exactly what you're talking about. And we see a lot of marks coming in that middle ground, the suggestive place where, well, I kind of know what it's giving me, like eat clean grow is a good example. Eating clean. It's these very simple prepared meals that are delivered to your house, but they're clean. So that means something to the consumer, especially if they're a fitness person, they know exactly what that means. But I wouldn't have known that until I started working with that client a few years ago. So I'm going to kind of skip through these, but here we get some examples of marks that we might all know, where there are clients like here we represented Dextrim for a number of years, but fanciful, right? They really are words like that don't mean anything unless someone educates you about it. Again, we talked about arbitrary, suggestive. Again, these are some good ones where you get kind of an idea what the product is, like the Gravity Vault indoor rock gyms. Like that's a great brand, like Microsoft Coppertone, very suggestive to the consumer of what their brain is going to look for when they see that. What is the product that's coming? And here's some descriptive ones. Again, I'll just kind of skip through these, but they're like American Airlines, a very descriptive name, but through, their logo is protectable, but a very well-known famous mark now because of sales and usage. And then generic, I mentioned aspirin, super glue is another one, escalator. Anyway, we put those there. And again, we've talked about this. Again, we've included these slides just really more for you to have at your fingertips if you want to go back and review. But we've just talked about those key factors. And we've, I'll just talk briefly about sort of the rights and how you obtain them. So the Lanham Act is the federal law that regulates trademarks. And as we note here, we talk about how you can start an application, whether you intend to use it, you're actually selling it in commerce. Doesn't matter now. You can, for years you've been able to do that. But you filed a trademark registration to put people on notice that you're claiming rights to that mark in connection with certain goods and services. And it expands your rights all over the country. So once you have a registration, even if you just sell in a couple of states, you could stop people from selling similar or confusingly similar products in other states throughout the country. And it is territorial. So the federal registration in the US just gives you rights within our borders. And every country has its own, almost every country has its own trademark registration process and different laws. And we also do that. We have clients that have international trademark portfolios, which will be beyond this, but just be aware it's territorial. If you got a problem in Canada, you got to go register in Canada and follow those, and protect those rights there. Here we briefly summarize the basic advantages of the federal trademark registration. Again, something we spend a lot of time doing. It's a presumption of ownership. You go to court, you have that certificate of registration. It's really powerful in terms of quickly showing you own it, puts the public on notice of your rights, and lets you use the Circle R. And it's also the basis of some foreign registration in certain countries. You can just, like they can here, we can do the same thing in foreign countries and say you're registered here, you like to be registered there. Again, it's all based on sales, so you've got to be using the mark in foreign jurisdictions, and you're listed in the USPTO database, which is probably one of the key things too, because now everyone can quickly search online and find you. So again, I don't want to go too deep into the registration process, but if anyone's dealt with it before, you file the application after you do some searching, and we put the information here so you have it at your fingertips again. Again, I'm trying to be mindful of everyone's time, but this is the process of filing it. We find these days they've lost a lot of examiners in Washington, but they're hiring new ones. It can be a 6 to 18 month process to get through the registration, so you clear all the hurdles. So that's kind of what we're experiencing right now.
And one thing to be aware of too is you file the application, and even without the current delays, it would take at least 3 months to even be assigned to an examiner. So you're really not going to get any feedback from the USPTO for about the 3 months to begin with. So that can be problematic if you're, you want to launch something quickly as opposed to having the luxury of, having something launching further out where you can get a decision ahead of time.
Yeah, and that's a good point, because that's really where your screening work and your research pays off. If you feel really confident that no one else is using it, you've got counsel to help you saying, yes, that's a register, you can register that, that's a strong mark, it's not descriptive. Then during that 3-month period while you're waiting for a response, you could start, ramping up and start using that mark rather than saying, well, we have to wait, our hands are tied. But that's the key to that intent to use application. You can file that even if you're not sure if you're ever going to sell it, but you like the name. Sometimes we encourage clients, well, let's file it, or file a couple that you like, and let's get them in and see how the trademark office responds, especially if it's not clear, not a clear-cut answer about descriptiveness or how it's being used, especially in a new market with new products. This slide really is a summary of what's in the application. Again, pretty detailed, got it at your fingertips. After you apply, after you get your registration, then you have to maintain it. And the key to this is to make sure someone at your company is monitoring and maintaining your trademarks. You don't want them to be abandoned or expire. You have filing obligations at the end of the first 5 years to declare file a statement declaring you're still using it. With a trademark, you can renew it indefinitely. So then you've got another one at the 10-year mark, and then every 10 years thereafter, you just have to file a statement saying, yep, we're still using it, we own it, it's ours, and we want to continue, and you can have the trademark for forever. Let's see. So we've been talking about sort of this critical aspect of protecting trademarks. Again, if you hear about a problem, make sure your team knows to report it up. Monitor misuse, take action to stop that, and don't allow others to use your trademarks without your approval. And on this next slide, these are kind of the things that we tell people to watch for. Third parties using your trademarks or similar ones. Again, that similar ones, it's likely to be confusing. Not actually confusing, but likely to be confusing is the key there. Any third-party use of your trademark, where they start using it in descriptions or as part of the way they're describing their own products, put a stop to that. Here again, we emphasize if you're not reporting it or taking action, you can delays in taking action to enforce your rights. There's certain legal concepts like latches and waivers that courts look at and say, well, if you didn't care for 2 or 3 years and the person continued to do it with your full knowledge of it, so it weakens your rights and limits your remedies. If those are things you just want to be on top of it and make sure someone on your team is maintaining the trademarks and then monitoring any misuse and reporting it up. Again, this is some of the slides. Again, we've got the information here. Make sure no one's using it without your approval. Here's kind of a focus on licensing. If someone's really using it, wants to use it, have a license agreement. Limit their use of it and have them under your control with a contract versus just maybe an email. And sometimes that happens. You let trusted partners in the industry use your name. You want to really be careful with that. Again, I think Brian's mentioned this, and I've said it too, like maintain records, promotion, sales. This is really that summary of, keeping representative samples of products. We love it when we go to a client and they've got like sort of a showroom with the history of the products, and someone just keeps shelves full of products and examples. It's really great, and it really helps if you're going to try and take on an infringer. So this, so we're getting close to the end of sort of the first part of this, and which is branding, trademarks, and this is really the key concept. When I talked about before about it's between the ears. If you're talking about an infringement or someone misusing your trademark, you're going to be talking about the likelihood of confusion. Again, confusion. Would a consumer looking at your product and this competitor's product be confused about where the source of that product comes from. That's what the court is looking for. It's really, as we know here, it's the foundation of trademark law. So, and there's a whole matrix that every court goes through, a matrix of criteria the courts look at to evaluate it. You don't have to remember all of it. You just have to understand, to help your team be successful, that there is this matrix. So if somebody comes in and says, oh, this guy is ripping us off and infringing our product and we need to take some action, you have to sit back and say, well, is there a likelihood of confusion? And every federal circuit has sort of its own, to be even more helpful, they have their own test. And I just cite here the Third Circuit case, which is what New Jersey is part of, to look at some of those elements. And then on this slide, I list them. So this is that matrix. Again, I don't want to go into every issue, every item or factor, but this is what you'd be looking at. Is there actual confusion? What was the intent of the person when they adopted the mark? Are the consumers actually in the same channel of trade? Are they really competing on the same shelves? All these factors weigh in, but I just want you to be aware of it. So if you're making that analysis before you, hire counsel and start going after someone, really think about this likelihood of confusion issue, or call counsel and ask about it. Say, what do you guys think? This is the key threshold issue that we talk about all the time when clients call us about, when it bubbles up in the, outside of the company, say, yeah, this is a real problem, and here's why we think so. This is the matrix that we sort of ask questions about, so you should know this and have it at your fingertips.
And this is also, Tony, if there was ever a lawsuit, this is also a good roadmap for the type of documents that we would come to you and ask you to assemble and preserve for litigation.
Yeah, for sure. No, for sure. And sort of here's the summary of what your options really are: is file a federal lawsuit seeking an injunction, stopping the party from doing what they're doing, and get monetary damages. And sometimes you can get legal fees for that. You can also file a TTAB proceeding. So the U.S. Patent and Trademark Office, within the Trademark Office, they have their own sort of court system, I'll call it. It's a good way of thinking about it. But it's called the Trademark Trial and Appeal Board. And if you don't like what someone's doing, or that they have a registered trademark that you don't like and it infringes on your rights, you can file there and try and knock out the registration. It's much like federal court, but it's a lot less work. There's not as many. There's no depositions, for example, typically, and it's more of like a paper submission and a decision. But they don't issue injunctions or award money damages. But you could cancel someone's trademark, and then that's a significant blow to their, their branding and their trademark rights. Also, we do a lot of cease and desist notices. Try and work, especially if someone's doing something that doesn't you don't like, and they may not be aware. You put them on notice. You tell them what your rights are, and then usually we try and work things out quickly and easily, so the business can get on with the business of doing business and not firing up the litigation engine, which again is a significant decision. Can take a lot of time and energy and money to go after an infringer. But the cease and desist notice, but there's no legal requirement to do that before you file a federal lawsuit or file a TTAB proceeding. It's just the traditional step that sometimes you take and sometimes you don't. Here again is just a quick summary of the remedies you get in a federal lawsuit, and I mentioned them quickly, but I just wanted to summarize them here so that you can see this is the real benefit of having the registered trademark and enforcing your rights. These are the things that you can get, and significantly, the primary thing is the injunctive relief, stopping someone from infringing on your rights and then recovering money damages. And now I'm going to turn to sort of the thing that we've been hearing a lot from clients about in the last few months during this remote working and marketing in the pandemic. Is what do I do? Now we're focused on selling online, and we're having these sort of common problems. Like, for example, even this week we have a client with a registered trademark, and they're just sort of getting focused on doing a lot more online marketing and selling. They've done very well in traditional selling, but somebody has registered their trademark, the exact trademark, as a domain name. And you go to that website and it redirects you to a competitor's website, but they're not using the name improperly on the site. They're not doing anything other than they registered the domain name. And if you click on it, you think you're going to get, well, this is not the trademark, but, FordMotorCompany.com, and you click on it and you go to the GM, buy cars online website. So I just wanted to summarize here some of the basics of that. If you're not familiar, you need to know this. But if someone registers a domain name that incorporates your trademark, identical part of it, something, you can use this UDRP dispute resolution. So ICANN is the Internet Corporation for Assigned Names and Numbers. It's the quasi-governmental organization that regulates all domain names. But if you register a domain name, whoever does it, through any registrar, GoDaddy, all the other ones, you're subject to the UDRP proceeding. It's a mandatory administrative hearing, and you file a complaint. You pay the fee. The fee for a one panel person is, I think it's $1,500 currently, but it is really a paper process. So if someone's sitting on your trademark, you can use this UDRP process to get the domain out of their hands and back in yours. Some of the key things is there has to be that identical or confusing similarity. They've got no legitimate interest in your domain name, and it's sort of a bad faith registration. And it's being used to create confusion or for commercial gain. Those are kind of the basic elements of it, but the key is to know that every domain name is subject to this, and you can use this proceeding to try and get your trademark back. The key is that it's a simple process. There's filing fees involved, but at the end of it, you do get your trademark, this domain back. But it's the only thing that you get out of that proceeding. In contrast, if you want to elevate that a little bit, there is relief through the Anti-Cyber Squatting Consumer Protection Act. So that's a federal law. It's an add-on to the Lanham Act, which is the main trademark law. And what you need to be aware is that you can, instead of doing the UDRP proceeding, you could file federal litigation to get your domain back, but at the same time sue for trademark infringement and get injunctive relief for them to stop selling the product or using the name, get an accounting of the profits, and get all the traditional trademark monetary damages and awards through that lawsuit versus through the proceeding and the UDRP that is really just for getting the domain name back. We've done that many times using the UDRP, and it's a pretty straight one. Once you prevail in that, especially if the party doesn't respond, then you just go through a process where the ICANN transfers the credentials to own and control that domain over to your account wherever you hold it through whatever registrar. But these are sort of the tools that you have to be aware of. So if someone raises that issue and says, "Oh my God, someone's got our trademark in their domain, what can we do?" These are the two things that you can do, in addition to sending a cease and desist letter and asking for cooperation without these formal steps. But we find typically that if someone's doing it, they're not likely just to voluntarily give up the domain name. So that's kind of the big picture of a common problem. The other thing we hear a lot about is sort of, if you haven't done a lot of it, is issues with sort of online advertising. And one of the things is this pop-up advertising. So this is a big concern for trademark owners because it happens all the time. You're in searching for something, and you get these pop-up ads that populate the screen. Doesn't matter what site you're on. It could be a search engine or a news provider or a magazine that you're reading, and these pop-ups come up. But we just wanted to clarify, like, courts really don't see this as a problem as long as those appear as separate windows and do not use in your case, your trademark in the advertisement. So if I'm searching for Goodyear tires and these pop-ups come up for Uniroyal or for some Continental tires, the competing products, as long as they're in a separate window and you don't use another trademark in the advertising, it's fine. Again, that goes back to, is the consumer confused? That's what the courts are looking at. And they found pretty uniformly that, it's not a problem. It was a problem in the beginning because no one liked it, but since there's not really confusion, you know it's a pop-up, you know it's not the same company, then it's fine. Another big area that we get a lot of questions about is keyword advertising. So, Google and the other search engines are selling trademarks and other keywords that are being used to search for products in the search engine. So you can buy your competitors' trademarks as search terms and have your company offered to the people searching for your competitors' products in the form of an ad. And we all see that and know how it happens using Google. Typically, that's what everyone uses. And the concern is, you're searching for your products and all your competitors pop up ahead of you or around you, and it clearly says it's an ad. And they have sponsored links, and there's if you've seen it, there's kind of a gray area where it's maybe not so clear that it's an ad. And what we found is that the cases are mixed on this. Like it really comes down to that confusion issue. So there's no bright line test like the pop-ups yet. But certainly Google can sell your trademark as a keyword through their AdWord program. Certainly they can, if someone searches for your product, they can offer up other companies' products that are competing, as long as they're not causing confusion. And that's where you just got to be aware and monitor it and have someone doing searches and really looking to make sure that there isn't misuse, where that your mark isn't somehow snuck into the description line of an ad that's being used through Google Ads, Google AdWord program. It's really comes back to that confusion issue. So that's why, again, it's sort of a very key thing, and you just have to monitor it. Similarly, we get a lot of questions about social media. Hey, our trademark's being misused. It's out there. What do we do? Now we're focusing on getting our brand out there and doing some social media marketing. Well, probably we've all used it. We all use different platforms, but the really biggest risk is employees and third parties sort of misusing it. And things are created quickly. They're not really being reviewed internally the same way you might for some advertising or other things, like print media in particular, or updating your website or your product packaging. So that's what leads to sort of these problems. And your trademark or brand can be misused in hashtags. We see it a lot in usernames. Someone's incorporating your trademark into a username, or even create a Facebook page about your product. And we sort of look at it as fans versus infringers. Like sometimes you just have fans, and that's great. People love your products, and we see that. Like I just have one sitting on my desk here, a Yeti, tumbler, YETI. People love those products, and they fans all over the place. Well, that's good as long as it's not someone infringing, using it to sell sort of competing goods, to draw you over and say, yeah, those are great, but you don't have to pay the premium price, and you can get ours that get 5 for the same price as one Yeti. And they're diverting your customers through the social media misuse. So a couple of things we talk about is a social media policy for employees and third parties, especially employees. Hey, it's great to use social media and talk about our products, but be careful how you do it, and regulate it, and also get ahead of it. Create your own social media sites. Create usernames that you think people might take with your trademarks. Just create them and own them and control them for your brand and for your own social media sites. Create your sites. Get ahead of it. Don't just try and be reactive, because you don't want to be trying to complain to especially fans like, hey, you're misusing our trademark, and stop it. And they think you're great. It's sort of it's a recipe for a bad outcome, especially if they start publicizing online that, oh, what a overbearing corporate company is that's trying to make us stop using their trademark, and we're just talking about how great the products are. Let's boycott this company. That's these things are real and happen, but that's a real basic step. Have a policy for employees and third parties, especially people you do business with, and then do your own registration of key trademark and usernames on social media sites. And then through the last two things we want to talk about, and I'm mindful of the time, let me just quickly go through these. But one of the biggest things that we've talked to people about as this switch to remote working, remote marketing, and online selling is they're just starting to get going on Amazon, eBay, Etsy, these types of online marketplaces, which is great. But it's just like if you're selling through your traditional channels, they all have their own policies, they all have their own rules and requirements, and it can be complicated. And you really have to monitor, review, have someone watching each of these marketplaces to see how your products are being sold, who is selling them, what the pricing is, to understand what's going on, and then really take action to be a trusted seller of your own products online, but you may be competing against some of your resellers. So that presents some problems. We see that a lot with clients that are sort of trying to take back Amazon and eBay from their own customer base. Very interesting dynamics there, but be aware of it. So like, hey, before you flood the online marketplaces with lower priced products, you might be cutting off your own sales. So you got to be really mindful of that. But one of the biggest things from an IP perspective is that all of these marketplaces have a registration process for IP owners for registering their intellectual property. Here again, typically we're talking about brands, trademarks. So you have a registered trademark. You want to go to here, like for example, Amazon Brand Registry. There's a whole portal, a place to go. You fill out the application, you create your own brand registry account, and then you populate the information in there, and you become a verified IP owner. So when you see misuse on their marketplace, for example, on Amazon, you can send a note to their, you can make a complaint, and they will terminate the seller. If they're not an authorized seller or they're misusing your brand, that's the quickest way to stop it. You don't need to file a lawsuit. You don't need to do anything else other than complain to the marketplace using their brand registry platform. And all of the big brands, all the big marketplaces have these registries. Important to do it. Have someone, while you're monitoring the online marketplace for the sales of your product or the use of your brands, make sure you're verified and you can take action. One of the benefits there I've seen recently with a client is you get all kinds of additional reports and tools to monitor your brand that you wouldn't otherwise get. So even if you don't see a problem, become a verified IP owner, get the tools, use everything they have to your advantage to really police these marketplaces, and then to take back these marketplaces for something you control, or at least recognize that if you have a lot of resellers that are selling the products, that you want to monitor it, and you don't want to maybe compete with your own customers. So you've got to be careful. But that goes back to that monitoring, reporting, and enforcing the rights, right? It applies on the online marketplace just like it would in traditional markets, but that's something we see a lot of. And then the last thing, I'll let Brian comment on this.
Very similar to the registration with those online marketplaces, the Customs and Border Patrol has an e-recordation program that allows trademark and copyright owners to obtain border enforcement at the various ports of entry. CBP has authority to detain, seize, forfeit, and ultimately destroy merchandise when they seek entry in the United States if it bears an infringing trademark or copyright that has been registered with the USPTO or the Copyright Office. But you also have to register and record it with the CBP, either the trademark or the registration. And just to clarify something I said before, in order to register a trademark, for instance, with CBP, it has to be on the principal register. Those are those stronger marks we talked about, the fanciful, the arbitrary, and suggestive. And I'll clarify what I said before. Even if you have a merely descriptive mark, oftentimes if you apply for something that's determined to be merely descriptive, you'll get a letter back saying, hey, you can't go on the principal register, which gives you the broadest protection, but you do have the option of putting it on the supplemental register, where you can still use the circle R symbol, and people would still search it and see that and may avoid using your mark. But noting that distinction, in order to register with Customs and Border Patrol, you have to be on the principal register. And then when you do so, you pay $190 per international class that you sought coverage for in your application. You might, seek for clothing or for restaurant services. Those would be two international classes. So the filing fee would be based on how many of those you sought in your trademark, and you can renew it. Just every time you renew your trademark registration with the USPTO, you can renew this for about $80 per class. And as part of this, you can give the Border Patrol personnel, you can create product identification guides to aid them when they get a shipment in and they inspect it to tell whether it's genuine merchandise and distinguish it from infringing goods. And the CBP gives like examples of those. You got to keep up to date on them as your products change over time. They also allow you to give training to the personnel at the ports of entry to help them understand the differences, and even to give them live online training in this environment. So that's really that. And if it really gets serious, I recently saw a seminar elsewhere where there's the Homeland Security Investigations is the overarching, well, this actually has the key role in a consortium of about 27 government international agencies such as the FBI, the DOJ, the Inspector General, the Army, et cetera, Interpol, where they try to shut down things like counterfeit masks, something if it really affects like the public safety or a microchip that may go into a guidance system on a missile that you don't want to have some sort of knockoff there. If something rises to that level, they can get involved. And the same thing with the FTC. Again, if it primarily relates to consumer safety, they're going to be the most interested. They're a little bit understaffed. They'll say to you, but that's if you have a type of product that really might affect the consumer safety. We could really escalate it to above and beyond these kinds of border patrol or that sort of issue.
Yeah, so as you can see that is a really powerful tool that and we see that a lot of times just missing from clients. They're just not thinking about it, and they've got a problem with knockoff products or infringement, and it's coming in. Oh, these things are coming in from outside the country, and we're not sure how to stop it. Go online, register with CBP, and start pushing some buttons. And you want to obviously identify they're sort of the legitimate companies that do import and have your authorization. But if they don't, you've got the people at the borders watching for your products, and we've seen it really beneficial results there and great efforts to stop infringing products from coming into the country. So again, another one of the things that we've been talking to clients about as a step that they were just missing in their sort of trademark brand protection, going from sort of traditional work to online. And with that, I'll close and thank everyone for listening in. We hope it was helpful. If anyone would like a copy of the deck, feel free to send us an email or just send us a note in any way. We'll get it to you. And we appreciate it. If you have any further questions or anything in detail, on the last slide here is Brian and I, it's our contact information. You can easily find us going to our website. But if you need anything, you want to kick something around, you've got further questions or someone on your team has questions, give us a call. We're happy to help. And we really appreciate you listening to our webinar today. Thank you and have a great day.
Thanks, everybody.